and welcome to another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about delay in criminal trials. Cases that should have gone to the Supreme Court of Canada, but didn't. Delay in criminal trials has been a huge issue ever since the decisions in Jordan and Cody. And how those cases are to be applied, and how the new presumptive sealing framework is to be applied, is an issue that courts continue to struggle with. This is what happened in Mr. Palenko's case. After he was charged with an assault, Mr. Palenko argued that the court should have exercised its discretion to just throw out the case entirely when it became clear on the record that there was no merit to the allegation against him. Mr. Palenko was unsuccessful, ultimately convicted at trial, and he appealed and lost his appeal. He sought leave to the Court of Appeal, arguing that there should be more guidance from the Supreme Court of Canada in the application of Jordan and Cody. And while Jordan and Cody have explained the framework for judges to dismiss motions and applications that occur in the course of trials, as soon as it becomes clear that they're frivolous or meritless, nothing about those decisions have talked about the role and the discretion trial judges have in dismissing cases in their entirety. And Mr. Palenko raises a good point. There is so much about Jordan and Cody that hasn't been considered by higher level courts and that affects the day-to-day running of courtrooms. The Supreme Court of Canada dropped a bombshell, attempted to clarify it, but really didn't give us what we needed to use that information effectively in day-to-day litigation of court cases. This was another opportunity the Supreme Court of Canada had to make things a lot easier for trial judges, Crown Counsel, and defense lawyers in looking at cases and in determining whether or not things need to be spoken to on the record about whose fault the delay is, whether the case has any merit, and how that affects the calculation of the presumptive sealing. Unfortunately, the Supreme Court of Canada denied the opportunity to do that and declined leave to appeal. This means that trial judges are left struggling to figure out when and where to apply their discretion and how to apply it in each individual case. Hopefully, the Supreme Court of Canada takes the opportunity to clarify the more nuanced applications of the Jordan and Cody decisions over time. But this isn't going to be the case to do it, and maybe there will be one in the future. You're watching Cases that should have gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos, and please like, subscribe, and share with your friends.